model of mediation or even for mediation. We are going to discuss three perspectives, this axiological, theoretical, and practical, praxeological perspective, and we are going to develop our thoughts on criminal law, criminal proceedings, also administrative law, and some aspect of private law, mostly by Katarzyna Zombory. So the first speaker today is Dr. Kowalewska. Her speech, her title of speech is Psychological and Victimological Aspects of Mediation in Criminal Proceedings. Dr. Kowalewska, could you now start your speech, because I don't see you very well?
Yes, of course I can. Just let me turn on the presentation, just a moment.
Okay, good evening.
Good evening, everybody.
So maybe I would present other speaker for today. So the next will be Dr. Ferenc Santha, discussing the characteristic of victim offender mediation in Hungary, legal rules and the lege ferenda postulates. And then me, I'm going to try explicate communicative act theory approach and argumentation approach as a basis for mediation in criminal cases as well. Then Dr. Peno, mediation and restorative justice, ethical and social background. And then Dr. Zombory, the legal framework, the European legal framework relevant to court proceedings and mediation in international child abduction. And the last speaker is Professor Rixer, and the topic is communication before, during, and after mediation. So I will remind the schedule following the speech of the first speaker. So could you start, Dr. Kowalewska?
Yes, I hope so. I just have small problems with presentation. Just a second, maybe I will try.
So it's very good because today I decided to go without presentation.
Okay.
I decided that maybe it could be attractive to you to see only me, not the pictures, because it's a little bit disturbing when there are a lot of pictures changing. So I decided today to try without presentation. Okay, I see yours.
Can you see now the presentation?
Yes, I can see. Please try if you can change
great.
the slides.
Okay. And now the slide has changed?
Yes.
Great, thank you. Okay, so that means I can start. I will try to tell something today about psychological and victimological aspects of mediation. At our last seminar in August, during my speech, I pointed out two working hypotheses trying to explain why mediation in Poland criminal proceedings is so rarely used. My first working hypothesis was that the fundamental reason is the so-called consensual mode of ending criminal proceedings, first and foremost conviction without trial and voluntary submission to punishment. My second working hypothesis was that not only the accused, but also the victim is not particularly interested in participating in mediation, for the simple reason that he or she obtains very little from mediation. Developing this hypothesis, I pointed out in August that in order to remedy such a situation, I mean to make mediation something useful for the victim, it would perhaps be necessary to adapt the mediation procedure and the mediation itself somehow to the victim. I already pointed out in August that maybe it would be necessary to take into account certain victimological and psychological aspects related to mediation, which perhaps seems to slip our minds with such purely legalistic considerations on of mediation. Today, I would like to develop this idea a bit more by analyzing a little more deeply what a victim can obtain from mediation, but not so much on a purely legal level, for example, by compensation, but also, or perhaps above all, on a victimological, psychological level. As I already mentioned at our seminar in August, one option here could be the formula of so-called victim-sensitive mediation. What is victim-sensitive mediation? In general, it should probably be considered as a variation of victim-offender mediation, so-called VOM. We may ask then what VOM is. We use this abbreviation in our seminars, and the simplest way to say is that VOM is mediation between victim and offender. It's clear, yeah? However, if we dig a little deeper into the scholarly works on VOM, this variety of mediation can be characterized a little more precisely. Namely, it is pointed out that victim-offender mediation is a process throughout which victims of crimes meet the offender in a structured and safe environment. And the goal of VOM is to create the opportunity for the victim and the offender to engage in a dialogue addressing their informational and emotional needs. During the actual VOM meeting, the victim and the offender talk to each other about the crime, discuss the effects of the crime on their lives, and describe their feelings about it. It is indicated that victim-offender mediation is one of the clearest expressions of restorative justice. It differs from other types of mediation primarily in that the involved parties are not disputants. Generally, one party has clearly committed a criminal offense and has admitted doing so, whereas the other party, I mean the victim, has clearly been victimized. The issue of guilt or innocence is not mediated, of course. VOM is not primarily settlement-driven, but is primarily dialogue-driven, with emphasis upon victim empowerment, offender accountability, and restoration of losses. However, even if we look at VOM in this way, it seems to have little direct relevance for the victims, what they would gain from the mediation. A little more information can be found in the results of studies on the effects of VOM on victims. In general, these results indicate that victims who undergo restorative process in the form of VOM, when they are compared with victims that go throughout conventional legal process without VOM and suffer the same time of crime, these victims after VOM show consistent and significant decrease in post-traumatic stress symptoms. They have lower scores on the scales of distress and fear. Many of the results also point out considerable reductions in negative emotions expressed by victims, such emotions like fear, anger, guilt, anxiety, distress, after, of course, their participation in VOM. The results consistently showed that the negative emotion of anger felt by victims toward their offender is lower also after VOM, compared, of course, to the levels of anger felt by victims who were subjected to conventional justice interventions without VOM. Furthermore, VOM promotes a reduction in feelings of helplessness about what has happened, along with an increased perception of security and self-esteem. What is also very important is that the surveyed victims indicated that VOM gave them a sense of emotional overcome, so-called closure, based on relief and emotional conditions to continue their lives. A victim. And three main effects of VOM can be here identified, I think. The first is obtaining a better understanding of what happened during and after the crime. The second is the opportunity to express emotions and thoughts regarding the crime suffered. I mean, the need for expression. And the third thing is the feeling that they are hurt and that their suffering is somehow valid, contributing to a greater perception that justice has been done. If we are already talking about victimization, it is worth to mention that it's not only primary victimization resulting from the crime itself, but also secondary victimization and so-called tertiary victimization, which takes place primarily in the victim's mind when he or she internalizes an image of him or herself as a victim, and his or her psychological functioning changes in accordance with this image, the image of victim. However, it is very important to point out that all these psychological benefits and dealing with victimization do not happen on their own. It's clear. It's not, of course, that if any criminal case goes to mediation, every victim's sense of anxiety and fear will automatically decrease. There will be a phenomenon of closure. The person will not hold a regret to the perpetrator. And yet, by the way, victimization of every kind, primary, secondary, or tertiary victimization will be dealt with. Of course, no. The psychological and victimological effects of mediation differ, primarily according to individual difference concerning the victims themselves, over which, of course, we have no influence in the mediation process. What we can influence is the person of the mediator. And this is why I think it is so important to raise the issue of the need to standardize the training of mediators, as well as to assess their professional quality in order to maximize the beneficial impacts for the parties involved in VOM, especially the victims. In addition to the person of the mediator, the second important issue, which is, by the way, closely related, is the appropriate shape and use of the mediation procedure in practice. And here we return again to the formula of victim-sensitive mediation. Refining its purpose in relation to that previously outlined with VOM, we can say that this purpose is to provide a restorative conflict resolution that actively involves the victims, mainly victims and offenders, of course, in repairing, to the possible degree, the emotional harm caused by the crime. And secondly, the material harm caused by the crime. Among the most commonly formulated basic principles of VOM in the formula of victim-sensitive mediation is firstly the victim safety. Simply, the mediator must do everything that is possible to ensure the victim will not be harmed again. To ensure the safety of the victim, the mediation should be conducted in a location that the victim considers safe, and the victim should be encouraged even to bring along a support person with him or her for the meeting. The second principle is careful screening of cases. I think it is maybe even the first principle, maybe even most important than the safety. Within the framework of this principle, it is simply important to select the cases that can and should go to mediation, taking into account the perspective and welfare of the victim at all times. The first element here is the type of the crime, of course. It is well known that cases of property crimes, traffic accidents, but without serious consequences, are quite promising in mediation. Much more analysis and, I think, caution is required when referring a case to mediation for an act that has caused or resulted in serious damage to health, cases of sexual offenses, or offenses against the family or guardianship. The second important element here is that the offender should admit his or her guilt, and the offender is able to express remorse. A case in which the offender denies perpetration or guilt should not necessarily go to the VOM, according, of course, to the formula of victim-sensitive mediation. Among the important principles of victim-offender mediation, it is also noted that the mediator should first meet not with the victim, but with the offender. Then, if the offender is willing to participate in mediation, the victim can be contacted and a meeting can be arranged. If the mediator meets first with the victim, gains his consent to participate in mediation, and later discovers that the offender is maybe not willing to participate, the victim may feel re-victimized, yes, having raised hopes for some resolution of the crime, only to be denied that opportunity by the offender. Aspects such being highlighted, although perhaps they are obvious. Yeah, we have the regulations about it now.
I can see that we have some technical issues with the speech of Dr. Kowalewska. I noticed 2 intervals, and now I cannot see her anymore. My proposition is to wait a moment. Maybe she will be ready to continue, because I suppose it was the last or almost last picture to describe. But for this instant, I may say that, for example, from my perspective, this speech is very consistent, even if I didn't know the scope of Dr. Kowalewska's presentation exactly for today, because I'm going to elaborate some theoretical approach for the optimization of mediation, victim-offender mediation procedure, and the elements highlighted by Dr. Kowalewska are very important from that point of view as well. So I'm very happy that we have this consistency of the speeches. So maybe a little one moment. Whether Dr. Kowalewska is with us? Because I see, following the list, that it is. She is.
I am, but I'm not sure if you can hear me.
And now we can hear you. Maybe you can turn off your camera, because I see that you have very poor internet connection. So maybe you can continue with the voice.
Now it's better?
Yes.
Okay. I'm not sure at what time the connection was broken.
So
probably
you highlighted the principles of victim-offender mediation from the point of view of re-victimization.
Okay, about this first meeting with offender, yeah?
Yes, and a few elements others.
So, frankly speaking, it was almost the end of my speech. Of course, the crucial question that still remains is about the possibility of adapting victim-sensitive mediation in Polish criminal proceedings. And I would like to raise this issue at our next seminar in October. And perhaps already then I will try to make some concrete de lege ferenda postulates, which maybe let us introduce this formula of victim-sensitive mediation to Polish criminal procedure. And that's all for today, I think. Thank you very much for your patience and attention.
Okay, thank you very much. And the next speaker is Dr. Ferenc Santha, and the title of his speech is The Characteristic of Victim-Offender Mediation in Hungary, Legal Rules and the Lege Ferenda Postulates. Dear Dr. Santha, the floor is yours.
Thank you very much. I don't know if you can see my PPT.
Yes, we can see.
Yes, thank you. As Professor mentioned, my title of my presentation is The Characteristics of Victim-Offender Mediation in Hungary, Legal Rules, and try to formulate some de lege ferenda proposals. First of all, I like to outline the objectives of the mediation process according to the Hungarian Criminal Procedure Code. The objectives is to reach the written agreement between the victim and the offender to giving reparation for the consequences of the criminal offense, encourage the future law-abiding conduct of the offender, and settle the conflict between the victim and the offender with the involvement of a person who is independent from the authority. He or she is the mediator. As I already mentioned, the victim-offender mediation has been introduced into Hungarian criminal law on the 1st of January 2007, and the legislation is based on three pillars: the relevant article of the Hungarian Criminal Code, which regulates active repentance as a ground for exemption from criminal responsibility, the rules of the relevant rules of the Criminal Procedure Code, which contain the relevant criminal procedure rules, and we have a special act on mediation process, the detailed rules of the mediation process from 2006. The procedure is of a mixed nature, since as I mentioned, the prosecutor has a right to suspend the criminal procedure and transfer the case to mediation if the statutory conditions are fulfilled. The prosecutor's decision is followed by the mediation process, which is, of course, a non-criminal procedure between the victim and the offender, carried out by the mediator, who can be in Hungary a probation officer or a lawyer. In Hungary currently there are two types of mediation. The common element of the two types of mediation is the central role of the prosecutor. The first type is mediation process in order to apply active repentance as a ground for exemption from criminal responsibility. This is the traditional mediation, where the scope of relevant crimes are limited. And the second form now is mediation process in order to make reparation for the consequences of the offense and to obtain a lighter sentence, which can name a new form of mediation which is applicable to any crime, at least in principle. What are the characteristics of traditional mediation? Is applicable in criminal cases if the criminal offense is a misdemeanor or a felony punishable with a maximum imprisonment of 3 years, and the offense is a traffic offense or an offense against life, physical integrity or health, offense against personal freedom, offense against human dignity and fundamental rights, and offense against property or intellectual property rights. In case of a successful mediation, the criminal procedure is to be terminated according to the criminal code. And if the above-mentioned felony is punishable with maximum 5 years imprisonment, the successful mediation will not terminate the punishability. The case goes to trial, but the penalty may be mitigated by the court without limits. Yes, and there are grounds for refusing mediation according to the criminal code. I have to emphasize that reiteration of the offense alone does not exclude the traditional mediation process, but mediation does not apply if the new intentional crime is committed during the probation period as a result of suspension of a prison sentence, or after being sentenced to prison and before she or he has finished serving the sentence, or the offense committed while released on probation. And mediation is also excluded if the new intentional crime is committed within 2 years after a successful mediation process, or the offender is qualified as a special or multiple recidivist, or the crime was committed in a criminal organization, or the crime caused death. And you can see that in case of traditional mediation, crimes relevant to mediation is limited. The limitation is based on the type and the substantive gravity of the crime on the one hand, and the circumstances that exclude the process on the other. In Hungary, the majority of cases referred to mediation process is offenses against property and traffic offenses. And we can ask the question that mediation process can be possible in cases of violent crimes. Violence against person, for example, battery or for example, robbery. I believe that current Hungarian legislation is adequate and serves as a model. Victims of more serious crimes generally reject the possibility of mediation. Therefore, the limitation based on the substantial gravity of the crime is appropriate. There is also a need to regulate the grounds for excluding mediation because certain perpetrators, based on their criminal records, simply do not deserve the benefits of mediation. And some words about the new forms of mediation, which can be applied from the 1st of July 2018, which is not linked to active repentance, and it can be used in criminal proceedings for any offense in which the objectives of mediation can be achieved. Its purpose is to make reparation for the consequences of the offense and to obtain a lighter sentence. Successful mediation is a mitigating circumstance, will be taken into account by the court. And the scope of relevant crimes is not limited. This type of mediation process applicable to more serious crimes, at least in principle. And I have to emphasize that the grounds for refusing mediation, which I mentioned earlier, do not apply to the new form of mediation. In theory, this solution is welcome because it could significantly increase the number of mediation process. Unfortunately, the statistics do not show this. Since 2018, when the new form was introduced, the number of mediation procedures has slightly decreased. There can be two reasons for this development. First, from 2018, the prosecutor has several other forms of diversion at his or her disposal. Second, the perpetrators are not sufficiently motivated to participate in the mediation process because successful mediation is only a mitigating circumstance to be taken into account in court proceedings. In my view, the optimal and appropriate legal consequence of a successful mediation is the termination of the criminal procedure or the unlimited mitigation of the penalty by the court. Successful mediation as only a mitigating circumstance does not encourage the offenders to participate in the mediation process. And some words about the conditions for both type of mediation, which is four conditions are in the Hungarian legal rules. First is the initiation of the mediation process. The second, confessional statement by the suspect. The third, of course, reparation. And the fourth is a very interesting and special condition, the so-called discretionary and subjective condition of the mediation process. First, the initiation and conduct of the mediation process. In Hungary, the investigative authority has a duty to inform the suspect and the victim about the possibility and the conditions of the mediation at the time of the suspicion is communicated. And later, the suspect, his or her defense counsel, and the victim has a right to file a motion in order to start the mediation process. Based on these motions or ex officio, the prosecutor has a discretionary right to transfer the case to mediation process and suspend the criminal proceedings for a period of 6 months. The second, the confessional statement by the suspect. The suspect must make a confessional statement has pleaded guilty during the investigation and no later than filing the indictment by the prosecutor. And the confessional statement must cover both the fact, the circumstances of the case, and his or her guilt. The third condition is reparation. The suspect shall provide reparation by way of the means and to the extent accepted by the victim within the framework of a mediation process or previously if approved in the mediation process. I have to emphasize that the scope and form of reparation should not be limited by legal regulation. Reparation can be provided in any form if it is not immoral or illegal. It all depends on the need of the victims and the parties' agreement, and which can be forms of the reparation, for example, material compensation, a personal service, the physical repair of the damage caused, or the offender's promise to undergo treatment or therapy for crime prevention purposes. An apology or other symbolic reparation or any other solution by the parties are all acceptable. And the fourth conditions of the mediation process, this is the so-called discretionary and subjective condition, because the other conditions are objective conditions, but this is a really subjective condition of the process. Because the prosecutor suspends the procedure for the purpose of mediation if reparations for the consequences of the crime are expected and criminal proceedings may be omitted, or the mediation process is not be contrary to the principles of the imposition of a penalty based on the nature of the crime, the method of the perpetration, and personal circumstances of the suspect. I have to emphasize that this condition is at the discretion of the prosecutor. Consequently, as I mentioned earlier, she or he has a very decisive role in transferring a criminal case to mediation. I have to say that this method, this condition can be criticized because the circumstances taken into consideration by the prosecutor are mostly connected to the crime or the offender, and the victim's needs are not a priority. And I have to ask the question why the prosecutor may refuse to refer the case to mediation if the statutory conditions are met. There are no grounds for exclusion, and both the victim and the offender request it. And what can be the solution? I can propose a solution, namely introduce a kind of a mandatory mediation or a mandatory diversion, as in Austria, for example, if the parties request the mediation and the objective statutory conditions are met. And finally, we have to ask the question that mediation, victim offender mediation, is a success story in Hungary. In my view, the legal framework of victim offender mediation is properly developed in Hungary, and Hungarian lessons can be used in the legal regulation of other countries. In Hungarian statistical data support or may support this finding. If you can see, in average 6,000 cases in every year refer to mediation process, more or less in different years. And if you can see the statistical data in Central European in Central Eastern Europe, in some Central Eastern European countries, in proportion to the population number of cases per 1 million inhabitants, you can see that the Hungary in the third place, and maybe we can say that mediation is a success story in Hungary. Thank you for your attention.
Thank you very much, Ferenc, and it was very interesting, and mostly the last picture when you decided to put this proportion between different Eastern Europe countries. So now it's time for my speech. I will follow the schedule to not exceed our, but the time is very correct for now, so we can proceed smoothly. So my topic for today is a continuation, of course, and it's a part of the article. So what I said before, it's a part of the chapter I provided, and now there are the inquiries connected with the article, which all group or members must provide as a part of results of our teamwork until November. So, starting this topic, the title is, of course, Communicative Act Theory and Theory of Argumentation as a basis for interpreting mediation in criminal cases. So just to remind you, I'm trying in all my research to highlight and mostly elaborate theoretical and even philosophical in some part and methodological basis to interpret mediation in general. My example is mediation in criminal cases because I am specialized at this field. But in general, most of my inquiries are about mediation itself. And my inquiries up to now allowed me to create 3 groups of theories. And the first group, it is I use the notion, so it is not it is quite convention to use those notion. But in first group, I include a core theory, and the core theory it is the theory I discussed before during the first 3 seminars. It is conflict resolution theory. I decided to name this theory as a core theory for mediation because in my opinion, conflict resolution theory, it is a proper theory to shape mediation as a legal institution. So whole aspect of mediation connected with law, but including axiological background of mediation as well. And this theory could be seen as the broadest and the most important for shaping mediation as a legal institution. So in first point, it is this core theory, conflict resolution theory. And then the second group of theories, I decided to take a name for the group for this group, optimization theories, and including in this second group, I decided to discuss the theory of communicative act approach, argumentation theories, speech act theories, and general theory of negotiation. It means behavioral theory of negotiations and game theory of negotiations. And optimization theories are useful for us to shape mediation and discuss the procedural aspect of mediation. It is very strictly also connected with the purposes of mediation. And when discussing victim-offender mediation in criminal cases, we must think always about the victim, the situation. Magdalena previously stated the principle of victim-offender mediation about the primacy of meetings. For example, the meeting with offender first which must be first before a meeting with the victim. So sequence of meetings and all this aspect I will follow which kind of rules I mean. And the third group, it is one theory which I would like to inquire, but the group is, I use the name, the theory on legitimization for normative structures. And the last group, it is quite abstract theory, contrary to duty directives. The last I will discuss soon next month. For today, we are at the group of optimization theories. So as I told you, I'm going to discuss the aspect of mediation, of the procedure for mediation, but not only from the legal perspective, but also from the psychological and sociological perspective, and discussing the aspect how to build the procedure, including those different, not only legal aspect of the procedure, also, or namely axiological second time, but also the psychological aspect. And but when starting, I would like to remind you my previous observation on victim-offender mediation, because victim-offender mediation could be shaped in very different ways, as I try to explain. So, but the most important for this moment is the beginning. Like, victim-offender mediation could be seen as a one form of negotiation in criminal process, in criminal proceedings. So both victim-offender mediation as a form of negotiation and the second form of negotiation, prosecutorial negotiation. And we discussed, not only me, but Magdalena and Ferenc before, that obviously there is a link between prosecutorial negotiations, because there are various forms of prosecutorial negotiations, and victim-offender negotiations. But in my point of view, it is not very clear how to establish those relations in inquisitorial form of prosecution, non-adversarial form of prosecution. I have some ideas at this. Maybe I will try to explain you at the conclusion of my research. So there are both types of negotiation. Victim-offender form of negotiation, mediation, is only one of those. And please, my remark is also about the name, because we observe, I think all of us, that it is the name victim-offender mediation. And the notion offender, it is not the case. So offender is a material, substantive name, and it means that the condition of mediation is to take this rule of being offender, not defendant, accused person, suspect person. So it's extremely difficult in pre-trial stage to decide about the charges, about the admission of guilt by defendant himself, and starting to be offender who decides to go into mediation with the victim. So this is a principal obstacle to enter into the procedure of victim-offender mediation, that the scope for mediation in criminal cases is very limited. So it is not a procedure to mediate the scope of criminal liability for defendant. It must be established previously before enter and starting the procedure of mediation. And now I can go to the core of my speech for today. So this communicative act approach. Of course, I would like to base mostly on the conception of Jürgen Habermas, And there are several aspects of this theory. There are, of course, the first assumption of rationality of the discourse between the participants of discussion, and we should discuss about the criminal cases in very careful way, because equality of participant for mediation is not that obvious as in the private cases. So we must provide some special protection for the victim. And as Magdalena stated this example about the sequence of negotiation, it is for the mediator to when elaborating the case, to start negotiation first with defendant, with offender in this procedure, and then to prevent re-victimization, to go with the proposition to the victim. So about speaking about the communicative act approach, I would like to concentrate on this aspect of equality. As I told you, a completely the condition for freedom of speech for the participant of negotiation in our case, and honesty of argumentation of the participants. And it is the second problem, in my point of view, the question of honesty of offender. That victim must be sure about the intention of offender, that he is first of all willing, and he is his repentance is pure, without any additional intentions, hidden intentions. So this is a basis for the best application of communicative act approach for the mediation in criminal cases. And of course, this is a challenge as well, how to create the condition for mediation to establish this equilibrium between the participant of mediation. Of course, it is a great role of mediator, and we discussed today that mediator must be a person trained in special way, and must be still this aspect of training for mediators is very important in the procedure. I think that mediators must be aware about different practical aspect of mediation, but also about the theoretical aspect of mediation, which I discussed, for example, today, like communicative act approach, how to follow those features of the best condition for interaction between the fragile participants of the procedure of victim offender mediation. And here we have also the conversational strategy. So it must be there are so many approaches to those strategies. So it must be, the mediator must be aware about those strategies. And there is also interactive model of discussion, which I'm going to inquire deeply. And there is also psychological model of neurolinguistic programming, which is very interesting in the field of mediation in criminal cases. It is a comprehensive approach to the issue of internship between language and thinking, and how to prepare the participants to mediation previously, before entering into direct contact. And then we are at the point to select whether mediation, victim offender mediation, must be performed in direct form or indirect form. This question I pointed out before during our seminar in August, that following the ordinance of Minister of Justice in Poland, for example, mediation could be performed in direct or even indirect form. So it is a very good option, and it is one of the opportunities that could apply this theoretical approach of the good communication, free communication between participants of mediation. A mediator must be concentrated on elimination of boundaries between participants, but it is extremely fragile question as well in criminal cases, to not indicate those problems which could be not convenient for the victim. And following certain legal rules that could be connected with those features, I have this ordinance of Minister of Justice of 7th May 2015, I indicated previous time, and there is of course the procedure how to proceed in mediation cases. And what is important, this is also some indication about location, about the place for mediation, and the mediation procedure shall not be carried out in the places occupied by the participant or the families of the parties to the trial. It could be performed in those places, but exceptionally and with the consent of the participants for mediation. It is one of the conditions how to build those conditions for the very good and careful communication of victim and offender. And special training for mediator, of course, it's not enough. We must discuss the question of the personality of mediator. This is not only the question of the legal requirement that the person who is a mediator and those conditions are strictly elaborated by law, but also the specific psychological test that mediators maybe must achieve, enter and perform before being a person which could be appointed as a mediator. And in this manner, we could discuss other established by law and introduced in the ordinance, but also the other conditions which are not took form of the binding law in Poland. So there are my inquiries in this aspect. And of course, at the end, I'm inquiring the form of speech acts, so like the communication act of offender and victim, which is not a part of criminal proceedings, but it is also a communicative act. So there are some formal rules for those acts. And I will continue with this topic later. So now I can conclude my speech, and the next speaker is Dr. Michał Peno. Are you ready?
Good evening. I have really short presentations, just 8 slides, so please give me a minute. Here we have the presentation. Yes, thank you very much. I will start referring to my previous talks and seminars, of course, by defining restorative justice. And as I said, I prepared 8 slides. The last one outlines kind of directives. And I must say now that I develop them in a book, in a chapter, and in my article. And today I'm going to add something to my last talk. The mediation is understood as a weaker form of restorative justice. And what we know now about restorative justice is that the common element of the concepts of restorative justice is that the process of this justice, the so-called restorative process, is understood, is considered as a process carried out essentially within the community, and moreover, generally aimed at improving the quality of life of this community. The general thesis of today's presentation is that each society must develop its own approach to conflict resolution, including conflicts. I need a kind of timer, so I'm sorry. Yeah, here is a timer. Okay. So as I said, each society must develop its own
I will be your timer. Don't worry.
Okay.
I have only trouble to be timer for myself.
Thank you. Its own approach to conflict resolution, including conflicts within a kind of legal relations, including restorative justice. So specific solutions must take into account the following conditions, I guess. Morality, a system of values rooted in one or another moral doctrine. Cultural conditions, of course, for example, customs, legal conditions, especially legal traditions and legal culture, legal order, legal traditions. By legal tradition, I also mean the kind of tradition of lawyers. Of course, economic conditions, for example, the level of wealth influencing access to legal services, etc. So, first of all, every society must create and internalize certain collective values, or communitarian, if you want this term. It is a question of culture and social order. So restorative justice is a good institution. This is also my thesis, that restorative justice is a good institution, and it can operate properly under the conditions of a collectivist, not individualist social culture. It means that the common goods and interests are preferred over individual preferences. Part of implementing a system guided by restorative justice values is getting to know the systems that make up a community. It includes, of course, the different systems, as I mentioned: political, legal, economic, and socio-cultural, and so on and so on. But the central question for me is what kind of society we want to live in, what kind of community we will feel comfortable in, how we want to live with other people. It means other community members. And here we have something more theoretical. Here we have something about the law policy or legal policy. I'm not certain how to translate legal policy. There is a term or concept of policy or policies, but okay, let's say legal policy. So typically, as you can see, as it is shown on this slide, legal policy is understood as a systematic set of social interactions aimed at achieving a specific goal within a specific social system. So understood in this way, legal policy also involves reflection on those areas that are to be transformed by law, of course. So the legal policy, the policy is based on a certain state of knowledge, including the analysis of the existing state and regulatory of social life. So I guess that such knowledge enables the selection of means to achieve the chosen goal. As is, I think, well known, legal policy concerns the creation of law and the application of law, of course. So how to apply the law to achieve the assumed state of affairs. So here we have the general question about values of restorative justice, so, or values that can be reconstructed from the most from the idea or conception of restorative justice. So as I said last time, goals equal values. So what values are behind the institution of restorative justice? I guess forgiveness, empathy, mutual kindness, openness, fairness, but of course not law as a law. Of course, this is another great problem, how to shape institutions of restorative justice, or one institution of restorative justice, referring to this kind of relational individual values. So what is the goal of legal policy? Of course, the ideal of social life. Here in this aspect, the ideal of social life referring to those values. Yeah, this is just an example from the literature. It represents, I think, common positions. Of course, the problem of community and how to define community. This is another great thing. Here we have what is the most important for me: the aspect of community, the actors of community, the inclusion of community or community members to the process. Yeah, so community restorative justice procedures strongly depend on a real, strong, and integrated community. According to commentators of various concepts of restorative justice and researchers of restorative justice programs, institutions and solutions such as institutions and solutions and this kind of institutions can be treated as restorative justice at all as an institution can be treated as a tool for rebuilding and activating the community and supporting self-governments and community autonomy. So I think that we have to think about restorative justice, about reform of law as a very good instrument to reshaping, to reform our communities or our community and our societies. I mean, Hungarian and Polish, for example, every. And of course, community can be understood in several ways. I think here we have a territorial, local community, as a set of relations and as a symbol. Now, I think that the last one refers to the perspective of Professor Janusz-Pohl. I think that this is what we need if we want to construct something of deliberative community. If we want to use the theory of speech acts, we need this kind of community, symbolic community. Yeah, but I think that now it's also worth referring to the Polish sociological tradition that, for example, in Szacha is quite well-known Polish sociologist, that community is created by people who are loyal to each other and share their brotherhood, resulting from conscious acceptance and acceptance of certain unifying values, mutual responsibility for their fate, and feeling a certain kinship in the way they see the world. So I think that it's a kind of synthesizing approach to the way in which we want to understand community. Okay, restorative justice institutions, including mediation, need to be based on the values of collectivist culture. This requires reformulating and supplementing the set of values implemented by the legislator. It is necessary to socially internalize the usefulness and effectiveness of mediation and other alternative forms of conflict resolutions. Restorative justice is primarily about repairing and strengthening social bonds. So, restorative justice serves to realization of a specific ideal of social life. This ideal is determined by a set of recognized values and specific attitudes, and it is certainly close to what can be described here as a collectivist culture and ethics of care, kindness, and co-responsibility. From the point of view of legal policy, it is important what measures will be implemented lead this goal. They will be presented, of course, in the form of general and specific legislative directives in article which I have prepared. So if the legislator, this is last slide, I'm going to finish my presentation. If the legislator assumes that the concept of restorative justice or chosen concept of restorative justice propose, speaking generally, good and desirable solutions, then the role of the state is stimulating and strengthening of communities and social bonds. And I think that there are no other ways in contemporary societies, let's say postmodern and prima facie liberal. Of course, it is the best that such activities on a larger scale should be undertaken by non-governmental organizations because in the so-called community learning process, they are more effective than state institutions. So rather volunteers, not police officers, should learn and coordinate mediations. However, the state must financially support and stimulate these activities. So, last two words, and as an essential measures of more than two, I think, an essential measure of a legal policy in the field of restorative justice should be to strengthen mediation and restorative justice in the educational environment, family, or in general public awareness. It should be a good practice to promote the use of these forms of conflict resolution in as many areas of social life as possible. It is necessary to support those initiatives that promote dialogue, empathy, respect for oneself and others, communication, nonviolence, etc. All this also requires the creation, I think, of public spaces, such as neighborhood meeting places, where problems and conflicts can be solved with the help of specialists. It is necessary to support and create a legal framework for social change towards the ideal of social life determined by mentioned values on which the institution of restorative justice is built. Maybe this is my I would say very general idea, a measure to reach this state of I would say to development of restorative justice would be creation a kind of a uniform mediation law, but I will write about it in my article. So tonight I must say thank you, and that's what I wanted to say. Thank you very much.
Thank you very much for this very complex and accurate speech. And now, the last but not least, speaker, Dr. Katarzyna Zombory. It's your time, and the last for today it's Professor Rixer.
So good evening, everyone. Thank you very much for all these very interesting and exciting presentations. I must say that very often I feel like an elephant in the china shop because all of your presentations are so consistent and coherent, and mine somehow stands out. I would like to add just one or two things to the presentation of Dr. Peno. It was very interesting for me to hear about your reflections on the conception of restorative justice and the connection with collective values. In my research work, in my PhD thesis, and well, it is my great scientific interest and love to deal with cultural rights of national minorities and indigenous peoples and tribes. And as you probably know, the restorative justice.
We have special guests.
Yes, we have two very special guests today.
So please take your place.
Siadasz? Siadasz, Miszku? Siadaj sobie. So the restorative justice somehow has its roots in the indigenous cultures, right? For example, in the Maori tribes in New Zealand, or in the indigenous communities in Americas. And somehow these communities thrive on the collective values and the collective identity. So it's very interesting, this remark about the restorative justice and the collective values. But just to start my own presentation, my today's topic is the EU legal framework relevant to mediation and court proceedings in international child abduction cases. During our last seminar in August, I spoke about the international legal framework, and I mentioned that the main international instrument relevant to cross-border parental kidnapping is the 1980 Convention on the Civil Aspects of International Child Abduction, which was adopted by the Hague Conference on Private International Law. The goal of this convention is to secure a fast return of the abducted child to the home country. As I also explained it, without losing time to carry out lengthy proceedings on custody rights. The 1980 Hague Convention is applicable to relations between the contracting states if both the state of habitual residence and the state of abduction, so the state to where the child was taken, are state parties to the Hague Convention. All of the EU member states are state parties to the 1980 Hague Convention, which is not surprising because all of the member states of the European Union are also members to the Hague Conference of Private International Law, and even the European Union itself as an organization has joined the Hague Conference of Private International Law. These two organizations, the Hague Conference of Private International Law and the European Union, somehow compete in creating cross-border cooperation mechanisms in Europe and in adopting conflict of law rules. In the field of procedural legislation on family law, these interactions between the instruments developed by the Hague Conference and the EU instruments are very strong. And for example, this 1980 Hague Convention on International Child Abduction is a very good example of such cross-influence and interplay. The European Union has adopted a legal instrument relevant to cross-border child abductions and the relations between the EU member states. And this instrument, which is the cornerstone of judicial cooperation in family matters in the EU, is the Council regulation on jurisdiction, the recognition and enforcement of decisions in matrimonial matters, and the matters of parental responsibility, and on international child abduction. It was adopted in June 2019, and it replaced the previous regulation, so-called Brussels IIb regulation of 2003, which had been in force for almost 20 years. So the new regulation is called different names, but most commonly it's referred to as the Brussels II Ter regulation. It entered into force this year on the 1st of August. Compared to the previous document, the new instrument brings some significant improvements and novelties. It is basically said to be more human rights-oriented instrument. However, the main idea of dealing with the intra-EU child abductions remains unchanged. And basically the main idea is that the EU law relevant to the cross-border child abduction incorporates the return mechanism regulated in the 1980 Hague Convention. The European Union has not designed its own unique mechanism to deal with cross-border child abductions, but it uses the Hague regime. The Brussels II Ter regulation and previously the Brussels IIb regulation, they were designed to reinforce the practical effectiveness of the Hague return mechanism in the cases between the EU member states. So in other words, the legal response of the European Union to parental child abduction is more or less the same as I presented it during our last seminar. So the left behind parent, it gives the left behind parent the right to seek the return of the taken child through the return application with the help of central authorities and the judicial authorities in the state of abduction. We can ask, what is the relation between the EU regulation and the 1980 Hague Convention? It is a very good question, and it used to pose a lot of difficulties for the domestic authorities, which were dealing with the international parental child abduction, and also for the scholars. Fortunately, the new Brussels II Ter regulation gives some clues on how to interpret the interrelation of the two instruments. According to Article 96 of the Brussels II Ter regulation, the EU regulation complements the 1980 Hague Convention. Certain modifications or additional requirements apply to the standard Hague return proceedings. For example, the EU regulation introduced more clear deadlines for the proceedings in the first and in the second instance. Also, compared to the Hague Convention, the EU regulation limits some exceptions which may justify the non-return of the child, especially with relation to the objection of grave risk for the child. However, these additional requirements or modifications do not alter the overall scheme of the Hague return mechanism. Most of the novelties introduced by the Brussels II regulation are relevant for family disputes, family matters other than child abduction. But what is important for our research and for our group is that the new regulation, Brussels II Ter, has put a strong emphasis on mediation in all cases concerning children, and particularly in cross-border child abduction cases. The regulation lays down an explicit obligation for courts to consider mediation in such cases, and if appropriate, to refer parties to mediation. According to Article 25 of the new regulation, as early as possible and at any stage of the proceedings, the court shall invite the parties to consider whether they are willing to engage in the mediation or other means of ADR. The courts are left with a discretionary power to decide whether mediation is appropriate in the given case, whether it will not unduly delay the proceedings or otherwise be contrary to the best interest of the child. Under the previous regulation from 2003, mediation was not unknown, but nevertheless, it did not lay any obligation on judicial authorities in respect of inviting parties to mediation. Unfortunately, apart from the obligation of the court to discuss mediation with the parties, the new regulation does not regulate the mediation process in the broader manner. It still remains within the domestic legislation, how to organize mediation and integrate it into the domestic return proceedings. While speaking about the mediation in cross-border child abductions under the EU law, it is important to mention that since 1987, there is a special office within the European Union dedicated to the promotion of amicable resolution methods in cross-border family disputes. It is the office of the European Parliament Coordinator on Children's Rights, which is currently held by the former Polish Prime Minister, Mrs. Ewa Kopacz. Originally, in 1987, when it was created, the institution of the coordinator was named Mediator for Children Victims of International Parental Abduction. And it was created on the initiative of the then President of the European Parliament, Lord Plumb. As we can read on the webpage of the Coordinator's Office, the creation of this institution was a pragmatic solution to increase demands that the members of the European Parliament were receiving from people facing cross-border parental child abduction. The role of mediator has evolved over the years, and in 2018, the office was renamed to the European Parliament Coordinator on Children's Rights. This change is supposed to reflect the evolution of the mandate, which encompasses children's rights. I think that the idea and the history of the office of the Coordinator on Children's Rights reveals and well reflects that the European Union has been encouraging mediation for a very long time now in family disputes. And of course, we should not forget that in 2008, so-called European Mediation Directive was adopted on certain aspects of mediation in civil and commercial matters. It created a legal framework for cross-border mediation as well. And although it did not explicitly and directly relate to the international child abduction cases, but it has definitely contributed to encouraging mediation and creating mediation-friendly environment in the EU member states. Thank you very much.
Thank you, Katarzyna. It's very interesting. Even it is difficult for you to participate in whole discussion when we mostly discuss the examples about the criminal law, and so I can see that it would be better to have more performers from the private areas as well. So I'm very so I regret that our team is so small. But I hope that we could enhance your research as well with our remarks. And the last, but it would be a great pleasure for us to hear Professor Adam Rixer, as always, very well prepared. So, dear Professor Rixer, the floor is yours.
Thank you very much, Barbara. Dear colleagues, the topic of my presentation is communication before, during, and after the mediation. Now I'm going to speak about the most important aspects of communication within the court mediation in administrative proceedings. In advance, I have to emphasize that court mediation in administrative procedure is a very specific and relatively new institution that requires also examination of the relations between the participants of such a process beyond the mere legal aspects. Within our Hungarian court-related, centralized model of mediation within administrative proceedings, that is well known also in Germany or Slovenia, the court refers parties to mediation. The court mediation takes place in a court building and is conducted by court-based mediation practitioners. The mediators are drawn from the judiciary or other members of court personnel. The mediators are chosen and appointed by the court, and the costs of the mediation are treated as costs of the justice system. In most of the cases, it means that these services are for free. So, what are the most important layers or aspects of communication within that court-centered mediation in Hungary? The first one is the communication between the judiciary and the society on court mediation in general. The second one is the communication between the judiciary and the parties of the certain case about the mediation. The third one is the communication between the mediators and the parties of that certain case. The fourth one is the communication of the mediators and the courts. And the fifth one is the communication between the courts involved if there are more than one, if there is more than one. I'm going to speak only about the first and the third one, because all the other aspects are laid down within legal sources by clear and ordinary provisions. So my first topic is the communication between the judiciary and the society on court mediation in general. My first remark is that the court's practice of advertising in Hungary is very moderated or restrained. It doesn't really exist beyond the web pages of the courts. Law is one such profession, even globally, where lawyers and law firms and other even state-managed legal institutions are not allowed or are only partly allowed to indulge in advertising practices to promote their services. And in spite of the fact that there are some reasonable legal barriers related to advertising practices, we can observe that, for example, the Hungarian Chamber of Court Enforcement Officers, in Hungarian Magyar Bírósági Végrehajtói Kamara for the Hungarians, quite often puts advertisements in television commercials. Thinking about the need for advertising, on the one hand, that could be or might be counterproductive by highlighting legal solutions when law must always remain an ultima ratio. But on the other hand, court mediation as a form of alternative dispute resolution is not a mere legal institution. Turning to the web pages of the courts, we can see that for the National Office for the Judiciary, it is compulsory to put a detailed explanation on its web page how to resort to mediation within administrative and civil court proceedings. Even though those web pages do exist, there are several problems related to them. First, in some cases, they introduce the content of the given legal source without substantive explanation. Moreover, the logic of the introduction follows the structure of the given act and not the way of thinking of an ordinary man or woman. Second, practical information is quite often hidden in long texts, overwhelming those who are not lawyers. Thirdly, the rules of court mediation within civil cases and administrative cases are introduced together quite regularly without mentioning the differences or making it clear that they are not absolute equivalents. Fourthly, some of them are too long, too short, or even too detailed. In general, the stable characteristics, stable features of that specific genre, I mean descriptions of court mediation, are missing. Fifthly, at least 2 web pages do not contain the regulations in force, but offer the content of the previous regulation. And lastly, the authority application form used for court mediation in administrative cases is accessible only in Hungarian. And it's funny that it is written there that if you would like to use a foreign language during the mediation, please appoint which one is it. If you would like to use Polish, you have to know Hungarian language. Last time the name of Kis Anna was mentioned by Ferenc. Kis Anna has been working for the prosecution service of Hungary as a prosecutor and as a researcher as well. It was my privilege to work together with her several years ago, and she's important for us because she's a representative of the law and literature movement inside law faculties and outside also. What is this movement about? The vast majority of the information about the law comes from web pages, from movies, and from fine literature, from fictions. And if it's so, even in the case of many law students, why shouldn't we introduce legal institutions through fictions, not directly, but through stories? In the case of mediation, through stories in which we could find portrayal of mediators or mediation processes. I was not thinking about the details, but maybe it could be a good direction as well if someone wants to promote the institution of mediation within the broader society. Next, my third point was about the communication between the mediators and the parties of a certain case. There are some questions to ask ourselves. What are the essential skills that mediators in general, and especially in administrative court cases, need? We can agree on the fact that communication skills are needed to speak and behave appropriately with the parties, that is, maintaining good eye contact, listen effectively, present your ideas appropriately, write clearly and concisely if an edited document is needed, and so on. The classical functions of communication are to persuade, inform, and motivate, which help parties make better decisions also within court mediations. There are several groupings that try to enumerate the main aspects of communication, and all those functions or aspects of communication are mediator development areas as well. One key exercise in dispute mediation is the management of emotions. Not only the disputant's emotions, but the mediator's own feelings. To reach that, effective mediators tend to apply interpersonal affect regulation strategies, for example, paraphrasing, active listening, or reflective practices, aimed at emphasizing cooperation and mutual understanding. There are several reflective practices that help the parties reflect on their experiences and actions in order to enable recognition of assumptions, frameworks, and patterns of thought and behavior. that shape their thinking and action. With these strategies, mediators promote empathic communication between the parties in conflict. But to be honest, sophisticated psychological toolbar is not as needed in administrative cases as in criminal cases, in criminal ones. In administrative cases, need for reconciliation or restoration is almost missing. The parties are using tools of mediation because of the possibility of forthcoming long-term cooperation. That is, the role of emotions and handling of those emotions is less important in administrative cases. But the most exciting question we can give ourselves is, are there any differences between the skills required from a judge performing as a judge and the judge who steps in a role of a mediator? From my perspective, we should not differentiate. A judge should practice civility by being patient, dignified, respectful, and cautious. Whatever his role within a court case or within an alternative dispute resolution process is. Might be the only difference is that there is a bigger scope for sociability in a mediation process. And beyond the conceptual models used to explain the human communication process, especially the communication between the mediator and the parties, a new field of research has been evolved related to the same topic: the need for holding virtual meetings and conduct online sessions. Unfortunately, it still does not exist in Hungary within these cases, mainly because of unsolved questions related to data protection. Thank you very much.
Okay, thank you very much. So just let me say that it was very complex, and actually it was very fast as well. You are always so complex, but at once very strict with time. And actually, we should follow your example, because now we exceeded 8 minutes our schedule for discussion. So my proposition is to maybe ask our guests, because we have today not 3 members from the public. So I don't know whether our assistant, Dr. Konrad Burdziak, would help us maybe with this task. So maybe there are the questions from the public, or someone who is a guest to our seminar would like to take the floor. There is someone, because I suppose we all follow discussion on the chat, and now there were comment by Michał Wawrzyńczak, for example, but we have also the participant Oleg Triboy and Wojciech Lis. Maybe would you like to give us your comments? Or I don't see. Thank you. I have no question. Thank you, Wojciech. But for us, it would be very important to have this impact from the public, whether we are, because we are following our research and we are in continuation of our previous speeches. So it is always good to know whether this is all clear for the new guests. So if there is no one who would like to direct the question by himself or herself, I think that we could conclude in short words the seminar, because I can say that discussion has been fulfilled on the chat. So now maybe 2 phrases of conclusion by each speaker. So starting by Magdalena. Magdalena, could you sum up?
Yes, of course. I'm trying to find the microphone, and I'm not sure where I have it. Yes, my conclusion from today is quite simple. I have the impression that every month, after every hour seminar, we are step by step a little bit closer to the
So devil devices, I can say.
in legal regulations. And I have the impression that during our last seminar, which will be in November, as I could remember, we will have ready our de lege ferenda postulates and maybe some common idea how to put it in the legal shape. When I compare our first seminar from July to this one today, I think it's a long way between. It's a good sign for me.
Yes, I think that first of all, it is a result of the chapters, because when the scholar must provide finally a conclusive work, it is the moment to elaborate the thing and to set things up. So I think that it was very important step. And actually, I can prize the organizers. At first, I thought maybe it is too soon to provide the chapters in September, but now I think that it was quite good for our research plan. And so the next voice is to, of course, Ferenc Santha. Could you, Ferenc, sum up in 2 phrases the seminar?
I don't have special comments. I just like to thank you your interesting presentation. I got a lot of new information. I think a lot of new knowledges. Thank you.
Thank you, Ferenc. So I can say as a third speaker to sum up that yes, this impression of Magdalena is very close to mine. So I think that we are observing our research steps, and I think that we can find some connection between our remarks. Of course, my main goal is to incite you and open you to theoretical approaches, and to convince you that even when some concept seems to be very abstract, at the end they are very useful, and we can understand better mediation as a legal institution with whole the social, psychological, and axiological context. So it is my first goal, and even the small remarks sometimes could be very important for the whole research, whole result of research. And using my voice, I would like to add a technical comment. So about our meeting, because we discussed previously to meet on Monday, but my proposition is to postpone the meeting after 15 October, because it was the deadline to provide the final chapters, because I would like to very much discuss with you the scope of book, and I must wait for the final chapters, especially when 2 performers have been added to our research team in August, so they had a very short time to provide the chapters in proper way. So it is my proposition, okay? But just discussed about this on WhatsApp. But I would like to only say that we must probably meet after the final date to provide the chapters, proofreaded chapters, as we established. And now the voices goes to Michał Peno. Michał, could you provide us some?
Yes, thank you. Well, so many problems arose. Very interesting. I believe there is a consensus among us that we need more than just a draft law. We need a strong philosophical and social basis for changing the law in the field of mediation, restorative justice, and so on. So, as I said, I would say I produce technical directives for the legislator how to do it in order to have good legal solutions in this field. And I believe that it is really possible to reach this goal, to present a good quality proposition of legal solution, legal institution, also directives in the field of legal policy, which is also extremely important, I must say. So I'm really happy that I had an opportunity to hear theoretical analysis of mediation that was very, very inspiring, I must say. So thank you very much for that. And
Thank
of course,
you very
a lot of questions.
Yes,
I must say.
But I think that some of them I noted, and I think that we can discuss about them during our workshop as well, because it is not necessary to have the public during our discussion. Maybe one question, because we had chat, and for example, today I discussed this communicative act approach directives, and there was the question of how the attitude of offender must be shaped when entering into mediation. So just to discuss this aspect, of course, it is the objective reality of criminal proceedings. It is obviously that it is enough to accept the allegations, to accept the charges. I'm sorry, mostly. So if confession is not necessary at this point, but from the point of view of this idealistic concept, it must be something more even at the entrance. So it is this distinction between reality and the ideal conception of communicative act. But of course, I'm going to deal about this further and in my article, so we could discuss, of course, on our forum later this aspect as well. And now, Katarzyna, would you give us a last comment?
Okay, so previously I mentioned that I feel a little bit odd in comparison to your presentations and to your topics, but actually I have second thoughts. Basically, I think that mediation as an alternative dispute resolution method has its own specific features, regardless of the field of law where it is used. So I hope that also I will be able to write my chapter in the way that somehow it matches all the other chapters as well, and that this cohesion will be preserved. But once again, I find it a very exciting subject, and for me it's a great pleasure to be here and to work with you.
Yeah, thank you. It's also our pleasure, of course. I think that everyone is sharing the same emotion. And the last word to our Professor Adam Rixer, maybe you would like to give us the last comment or some conclusion.
Thank you very much. Although I'm the only one who is usually speaking about administrative topics, criminal law was always my favorite, and I'm delighted. I'm eager to hear your interesting presentations. Thank you very much. And I've wrote down several questions, but I do not want to waste your time, and because of that, I'm going to give you only one, Barbara. You offered specific groups of theories on mediation, and the very last one was, if I'm not mistaken, legitimization of normative structures. And you told us that you are going to speak about that topic next time, but would you summarize what is it about only in one short sentence?
Yes, yes, I'm very eager to do it, but I know that it is a very abstract concept. But generally, it's not my my idea that to link this concept with restorative justice. So it is a conception of contrary to duty directives or norms, and this conception is to create the basis for the legal norms which could be applied in the situation when the previous and other legal norm have been violated. It means in criminal law that restorative justice in general concepts are regulated by the legal norm, um, and their activation is at the moment when the sanctioning norm in criminal law have been violated. So when a perpetrator has violated criminal law, the norm of criminal law, it is the moment when the other norm, contrary to duty. So contrary to duty, it means that the duty have been breached, or the duty to obey the legal norm, other norm of the system can be applied. It is the concept which create the space for axiological legitimization of restorative justice, because as I argued during the July meeting in August, it could be in some cases controversial restorative justice. For example, in the cases of very violent crimes. So why using restorative justice in the cases of violent crimes? As we could follow the examples of Ferenc, in Hungary there are the limits for mediation. Only some crimes with not very high penalty could go for mediation. In Poland, we don't have those boundaries. So it is the space how to explain, even for society, why we can admit those legal norms which provide the opportunities for offender to have some profits, some benefits in criminal justice. So it was clear?
Thank you very much. Yes.
So because the concept is rather, it's better to write about this concept, I can say, because there are many discussion by the author of the conception and the Polish professor Sarkowicz, who applied those conceptions in 17th, but it isn't very well known approach. And I think that it is worth to be mentioned, and it is why I'm decided to develop this aspect. But it is rather for those researchers who are interested about validation and legitimization of legal norms. So it is, I would say, purely theoretical approach. So it is, I can say that the practical approach of this conception is not that high as conflict resolution theory or those optimization theory, which I discussed today, because by optimization theories, we can compare the idealistic situation of those theory and the practice. As you observed, it is at a minimum the condition to enter into a negotiation or to create a good space for discussion, like the location of mediation procedure. So it is obvious and it is very practical. But with this last theory, it is very theoretical, but it is important because we can have this linked. So in my vision, it is the link to what with I started. I started with the question on the model of justice in criminal cases, whether it is a retributive justice model or restorative justice model. And obviously in pure retributive justice model, there is no place for restorative justice, and there is no place for contrary to duty norms. So it is the closure of my circle, this conception. Thank you very much. So I think that I can close the seminar for today. And as we discussed on the chat, I will write to you. And when I get the last final version of chapter, we could meet.